Hello class. I chose to do my project on the Arizona versus Hicks case. Let me start by giving you a brief explanation of the case. But first, I want to let you know that the Fourth Amendment prohibits unreasonable search and seizures, not allowing for plain view search and seizure, and requires any search warrant to be judicially sanctioned and is supported by probable cause. In this case, a bullet is fired that injures a man. During a search of the respondent's apartment for a shooter and more victims, a police officer notices expensive stereo equipment. By moving the components of the equipment, the officer finds serial numbers which he records and calls in to headquarters. The officer is advised that the turntable has been taken in a previous armed robbery. So these are the facts. On April 18, 1984, a bullet was fired through the floor of the respondent's apartment. This bullet struck a man in the apartment below. Police officers arrived and entered the respondent's apartment to search for the shooter, for more victims, and for the weapons. They find and seize 3 weapons, including a 22 caliber sawed-off rifle, a 25 caliber automatic pistol, and a 45 caliber automatic weapon. Also, in the course of their search, they find a stocking cap mask. So, one of the policemen, his name was Officer Nelson, noticed 2 sets of expensive stereo components which seemed out of place. Suspecting that they were stolen, he read and recorded the serial numbers, moving some of the components, including a Bang & Olufsen turntable, in order to do so, which he then reported by phone to his headquarters. Being advised that the turntable had been taken in an armed robbery, he seized it immediately. It was later determined that some of the other serial numbers matched those of other stereo equipment taken in the same armed robbery, and a search warrant was obtained and executed to seize that equipment as well. The respondent was subsequently indicted for the robbery. But the mere recording of the serial numbers did not constitute a seizure. But the moving of the equipment was a search separate from the search that was the lawful objective of entering the apartment. But the search was invalid because the policeman searched on a reasonable suspicion instead of a probable cause to believe that the stereo equipment was stolen. Probable cause is required to invoke the plain view doctrine as it applies to seizures. A warrant would have been needed to search the premises. Probable cause to believe the equipment was stolen was also necessary to support the search here. Whether legal authority to move the equipment could be found only as the inevitable concomitant of the authority to seize it. Sorry about that. But also as a consequence of some independent power to search objects in plain view. The plain view doctrine does not render the search reasonable under the Fourth Amendment. The policeman's action cannot be held on the ground that it was not a full-blown search, but was only a cursory inspection that could be justified by reasonable suspicion instead of probable cause. The court was unwilling to create a subcategory of cursory searches under the Fourth Amendment. Another key to this case is Officer Nelson lied during the case, stating there was an opening of about a foot between the back of one set of stereo equipment and the wall. So Nelson acted as if the opening was large enough to permit him to view serial numbers on the backs of the components without moving them. Justice Scalia, in his dissent, states that in certain circumstances, a warrantless seizure by police of an item that comes within plain view during the lawful search of a private area may be reasonable under the Fourth Amendment. Justice O'Connor's dissent suggested that the search was a cursory inspection rather than a full-blown search, and could therefore be justified by reasonable suspicion instead of probable cause. Justice O'Connor states, in this case, no warrant to search the stereo equipment for its serial number could have been obtained by the officers based on reasonable suspicion alone. And in the court's view, the officers may not even move the stereo turntable to examine its serial number. The state contended that even if Officer Nelson's search violated the Fourth Amendment, the court should have admitted the evidence thus obtained under the good faith exception of the exclusionary rule. Powell, O'Connor, and the Chief Justice dissented. In Coolidge v. New Hampshire, Justice Stewart summarized three requirements that the plurality thought must be satisfied by a plain view search or seizure. First, the police must lawfully make an initial intrusion or otherwise be in a position for which they can view a particular area. Second, the officer must discover incriminating evidence inadvertently. Third, it must be immediately apparent to the police that the items they observe may be evidence of a crime, contraband, or otherwise subject to seizure. The state trial court granted respondents' notion to suppress the evidence that had been seized. This was affirmed by the Court of Appeals of Arizona. It was conceded that the initial entry and search, although warrantless, were justified by the exigent circumstance of the shooting, but the Court of Appeals viewed the obtaining of the serial numbers as an additional search unrelated to the initial reasons to search the apartment. This having been said, the Court of Appeals held that the police conduct violated the Fourth Amendment, requiring the evidence acquired from that conduct to be excluded. So both courts, the trial court explicitly, and the Court of Appeals by necessary implication, rejected the state's contention of Officer Nelson's actions were justified under the plain view doctrine of Coolidge v. New Hampshire. The Arizona Supreme Court denied review. As an initial matter, the state argues that Officer Nelson's actions constituted neither a search nor a seizure within the meaning of the Fourth Amendment. In my opinion, this case had no grounds from its beginning. Calling in serial numbers to headquarters because of suspicion does not warrant search and seizure of stereo equipment. There has to be a known fact beforehand that the equipment may have been part of a robbery. I think this case should have only been based on the shot fired that injured the man in the apartment below. I also question the fact that there was no focus on the reason for the shooting. There are no further details of the man who was shot, actually. So I have to wonder what the motive of the police was in this case. And that's about it for this case. I will also be given a PowerPoint that you can look at concerning this case. I thank you very much for listening and hope you have a blessed day. Aloha.